Good afternoon, sir, and a very good afternoon to everyone who's come back for the remaining sessions. I assure you we're going to have an insightful time right now. So, our next speaker is Professor Saurabh Bharati, who requires no introduction here at NALSAR. He had done his law from Delhi University, after which he's come to NALSAR to pursue his master's. He is now an assistant professor at NALSA and currently runs a seminar course on traditional knowledge and intellectual property rights for both the LLB and LLM students. He is also the faculty coordinator for the Advanced Diploma Program in Patents Law. Professor Bharati will be speaking on international IP regime and the developing world in today's session. Sir, please take it forward.
Thank you, Shireen. Also, I don't have a presentation, so don't bother making me the presenter. Primarily because my talk today is not data centric or information centric per se, but more in terms of arguments on the question of this relationship between intellectual property regime at the international level and the developing countries and the relationship, right? So good afternoon, everyone. Also, before I start, I'm suffering with a bit of cough. So in between, if you see me coughing, don't mind. Please excuse me for that. So as I see the list of topics for today, I mean, at least on the face of it, my topic would seem to be an odd man out of sorts. But then I had the chance of tuning in for a few moments to the previous speaker's talk, which is Shri Madhusudanji, and whatever little bit of him I heard, I think there is a sort of continuation from what he was talking about to what I'm going to talk about, right? So he was also talking about the waiver proposal. I mean, at least the time when I tuned in, he was speaking about the waiver proposal and also the practical implications of such a waiver proposal. So I am going to talk about the same question, but going to present to you the international sort of political and legal engagement which developing countries have been having with the international intellectual property regime, and sort of invite you to think about this question of a waiver proposal from that perspective, right? So it has two perspectives. One is a very practical perspective of how much it would be useful, when patents are still not granted, what is the purpose of waiver, etc., etc. So at a very pinpointed practical level, there are issues here, but and that is what presumably Shri Madhusudanji was also talking about, at least in part of his presentation. But as I said, so mine is a slightly different perspective on the question. So in that sense, although on the face of it, as I said, my topic was looking to be slightly odd man out, but it doesn't necessarily has to be seen in that light. So this pandemic has sort of renewed the interest in how developing countries engage with intellectual property regime. And that has happened primarily as a result of this proposal for waiver from some of the TRIPS obligations, which India and South Africa had jointly sort of presented before the TRIPS Council. Now, this proposal is not unique in a sense that waiver has been granted earlier also. Doha Declaration, for example, was an example of a waiver granted, and I'll speak about that a little later. But I'm presuming many of you would be familiar with the Doha Declaration. So waivers under TRIPS is not a new phenomenon in that sense. It's not a unique attempt, but the kind of waiver which is being asked for surely had a radical nature to it, because it was very extensive. It was requiring waiver against many substantive provisions of the TRIPS agreement, as well as the enforcement chapter of the TRIPS agreement, right? So the breadth of it, although it was specific in terms of specifying what all needs to be waived, yet it was broad enough, and in that sense, in my opinion, it was a radical kind of an attempt by the developing countries represented by India and South Africa in this case to engage with the international intellectual property regime. And that's why I say that the pandemic has renewed this interest in looking at how developing countries engage with intellectual property regimes. Now I see, as I said, when I tuned into Madhusudan ji's lecture, he was referring to the text of the waiver. For my own purpose, in order to secure my own momentum vis-a-vis this lecture, let me also highlight those important points of that waiver document. So it said that the General Council, noting with concern the threat to human health, safety, and well-being caused by COVID-19 pandemic, which has spread all around the globe, as well as unprecedented and multifaceted effects of the pandemic, including the severe disruption of societies, economies, global trade and travel, and the devastating impact on the livelihoods of people. Recognizing the need for unimpeded and timely access to affordable medical products, including diagnostic kits, vaccines, medicines, personal protective equipment, ventilators for a rapid and effective response to COVID-19 pandemic, decides as follows. In the draft, there were 5 articles. I'm only referring to the first one, which is the most relevant. Point 1, the obligations of members to implement or apply section 1, 4, 5, and 7 of part 2, which includes your sections on copyright law, patent law, designs law, and confidential information law, right? The obligations of members to implement or apply sections 1, 4, 5, and 7 of part 2 of TRIPS agreement, or to enforce these sections under part 3 of the TRIPS agreement shall be waived in relation to prevention, convention, or treatment of COVID-19 for dash number of years from the decision of the General Council. Okay. So this proposal created a fresh set of tensions within the international intellectual property regime. When I use the word fresh tensions, the meaning behind my usage of the term fresh tensions is that with respect to the TRIPS regulated or TRIPS centric international intellectual property regime, there was a period of calm and settlement in last many years. Although intellectual property as a matter of contention at international level was surely arising every now and then, but most of the times it was happening with respect to free trade agreements being signed between some developed country with some other country in the developing part of the world, and some sort of some people would call that arm twisting, some people would call that free negotiations between two countries, whichever way you put it, but some attempt to go over and above whatever TRIPS would require. So in terms of public attention, in terms of civil society's attentions, in terms of developing countries also showing some kind of discomfort with some developments, it was more with respect to how things were happening outside the TRIPS forum and not so much within the TRIPS forum, right? So it was either free trade agreements, like I said, or it was attempts to create alternative regimes. Like there was an attempt a few years back by the name Anti-Counterfeiting Trade Agreement, ACTA, to basically replace TRIPS as the most important intellectual property regulating treaty in the world, right? So in that respect, I'm saying that this proposal has created a fresh set of tensions, which was surely part of all TRIPS related discussions in international forums for initial part of the life of the TRIPS agreement, but in the recent past had seen, and I'm going to touch upon that or build upon that even further as I go ahead. But the moot point is that after a period of calm of sorts, there was a fresh interest because these tensions got created where some developing countries are seeking waiver and many developed countries, particularly Europe, was very stubbornly resisting any such issue. So the worry for the developing countries was that if there is an agreement which has the capacity of taking away from them the freedom to exercise their capacities to mount a joint kind of response to a global pandemic, which would surely have a specific kind of impact on developing countries, then such agreement needs to accommodate for the needs of these developing countries. Okay, so therefore it is in that respect this proposal I'm suggesting should be seen in the context of broader relationship which developing countries have shared with Indian international intellectual property regime. Okay, so my attempt would be to sort of justify my position to the extent possible, and then wait for an engagement from your side to see if you agree or disagree. So if we go back looking at this relationship as to how international intellectual property regime, which is basically a westernized conception of intellectual property, at least in terms of its origins. Okay, so if we go about looking at how it all got universalized and globalized, one starts from the period of colonialism, and one sees that intellectual property rights was part of the project of colonialism, right? So you had examples, just a minute. So many colonies, India was one of such examples. Many colonies had intellectual property laws even before many countries in Europe had many of those laws. So India's first patent law was in 1856, much before many of the European countries actually had their own patent laws. And this is because India was a British colony. Similarly, other prominent countries in Asia, Southeast Asia, like Malaysia, it was British Copyright Act of 1911, which was exported to some parts of Malaysia which were under the British Dominion, but other parts which were not directly under British Dominion were also asked to mimic the 1911 Act and have their own law. Philippines, their patent law was initially based on Spanish patent law, and then subsequently when Americans took over, it was the American patent law. Similarly with Korea, etc., etc. With some exceptions like Taiwan, which was sort of copying the Soviet model for a long period of time. Mostly the developing world, the intellectual property laws to begin with were part of the colonial project, and the laws were imposition from the colonial masters in order to obviously extend their own interests vis-a-vis intellectual property. Okay, so once after World War II, once countries started securing their independence, of course, the spirit of independence had to be reflected in the manner in which they would go about having their own laws, and including intellectual property laws, and that was visible. Again, India becomes the most prominent example for us. Some of you would be aware of the fact that post-independence, India started to have a look at why have patent laws, what are they doing for India, for innovation in India, for Indian masses. And as a result of that, a couple of committees were constituted to look at the relevance of patent law in India. The first one was Tekchand Committee. The second one was Justice Iyengar Committee, which is the more prominent of the two. So Justice Iyengar Committee particularly took a very on the ground or to the ground approach on patent laws. And if I can just quote one observation from that committee's report, it said that Indian patent system, which was sort of imposed by Britishers earlier, Indian patent system had failed to stimulate inventions among Indians and to encourage the development and exploitation of new inventions. And that patent laws have to be designed with special reference to the economic conditions of the country, the state of its scientific and technological advance, its future needs, and other relevant factors, so as to maximize, if not eliminate, the abuses to which a system of patent is capable of being put, right? So there was this acknowledgement of correlation between the socio-economic situation of a country and the patent laws, right? This correlation was obviously not necessarily recognized in the manner in which patent laws or IP laws in general, when those were borrowed or imposed by the colonial masters in different developing countries when they were colonies. So, so the point to be noted is that after getting independence, India did not decide to simply do away with patent law. India decided to use it as an important tool of regulatory policy, but to use it, in the background of the socio-economic conditions of India. So, if India still did not have a sufficient pool of innovators who would be required to be incentivized through a strong set of patent rights, then it did not make sense to go down that line of reasoning in order to constitute your patent laws. Similarly, if India had large number of population to cater to, particularly with respect to their needs for medicines and food products, etc., then it did not make sense at that time to have patent law, which would make it difficult for this policy objective to be achieved, right? So the most peculiar thing which is often cited about the patent law in its original form is that India did not grant patents on the products with respect to the pharmaceuticals, the chemicals, or the food products, right? This happened only after India became part of TRIPS. Now, when India took this position in 1970s, okay, and India was not the only country, by the way, to have taken such a position. Many other countries, including Brazil, Argentina, Mexico, and some other countries of the Indian region, were also diluting the strength of their patent laws when it came to pharmaceuticals and chemicals. Okay, but the interesting point to note is that India and some of these countries were not doing something radical when it came to tweaking the patent laws in this manner. They were simply following a tradition which had been laid down by the countries of the developed world when they had tweaked their own intellectual property laws at different points of their economic and social trajectory. Okay? So the case is that it's not that from the beginning, patent laws, copyright laws, or any other intellectual property law had one standardized sort of adoption across the world. Different countries, including from Europe, had utilized their freedoms to tweak their laws, or rather, in some cases, not to have patent law or any other IP law at all, depending upon how they were situated economically and socially, right? So I'll give you some examples. So there was a study done by WIPO in 1988 as part of its feedback to the negotiations, GATT negotiations on including intellectual property as part of the trade arrangement. So as part of that study, WIPO noted that out of 98 members of the Paris Convention for the protection of industrial property, 49 excluded pharmaceutical products from protection, 45 excluded animal varieties, 44 excluded methods of treatment, 44 excluded plant varieties, 42 excluded biological processes for producing animal or plant varieties, 35 excluded food products, 32 excluded computer programs, and 22 excluded chemical products. Okay, so there was diversity in terms of what all was protected or what all was excluded amongst the countries which were signatories to Paris Convention, and many of these countries were European countries or countries of the developed world, right? So what the developing world was doing post independence was not radical. It was as a model, it was already present. Okay, and in terms of diversity of approaches to patent law, the inclusion or exclusion of subject matter was not the only manner in which the diversity was present. If we go a little back in the history, we see that at different points of times in the trajectory of their socio-economic development, various provisions of patent law, which today after TRIPS came into existence, became impossible to be exploited. Various possibilities were exploited to the maximum by Europe and different countries of the Europe. Okay, so I'm just quoting one small observation here from a very important scholar called Susan Sell. She had done a study of the 19th century, scenario of intellectual property law in Europe, and this is what she had to inform. Okay, she says the 19th century witnessed considerable fermentation and controversy concerning copyright and particularly patent protection. The intellectual property landscape of the 19th century was a patchwork of diverse national laws and approaches to intellectual property regulation. As a matter of public policy, most states had adopted intellectual property policies to encourage migration of useful inventions to their territory and to facilitate reading public's access to an extensive range of published materials. These policies included introductory patents, which basically meant that anyone who introduces technology, even if that person is not an inventor, but an importer of technology, that person would get the rights. So these policies included introductory patents, compulsory licensing, working requirements, differential treatment for citizens versus foreigners, and by contemporary standards, weak or lax intellectual property protection. Okay, so all these points which I just mentioned for you are points of or are possibilities of how you devise your intellectual property laws. And many of those possibilities post-TRIPS became impossible for the developing country to actually rely upon. Okay, but something which the developed world at different points of time in their history had fully milked in order to ensure that their intellectual property laws remain relevant to their socio-economic conditions. Right. So Britishers, for example, had this tradition of rewarding introducers of technology, even if those are foreigners, whereas US was very particular about rewarding the local innovators and deny intellectual property protection to foreigners. Okay? So disparities existed in this manner also. not only in terms of the subject matter which is protected, but also in terms of who is granted patent and on what conditions patent is granted, right? There's one, I mean, I know that will consume some time here, but I think that is an interesting example, so I'll just quote it here. So in terms of case studies, I can just mention one example to suggest also that many of these countries in the developed part of the world, when they were grappling with the nature of intellectual property, regime they need to have for themselves, it was internal churning within these countries where various private interests were pitted against each other, and how those private interests were at times aligning themselves with different sentiments of let's say national security or public welfare or various other kinds of sentiments. There was an attempt to align oneself with such sentiments in order to secure the kind of intellectual property regime one wanted. Right? So US is an example, particularly with respect to its dilly-dallying, initial dilly-dallying on its position vis-a-vis the copyright law and Berne Convention. So for a long period of time, America, by the way, generally also America was an IP minimalist for a long period of time. It's only in the recent past that it has become such an aggressive state vis-a-vis intellectual property, and it wants to export its standards of intellectual property globally. But particularly vis-a-vis the copyright law and the subject matter covered by copyright law, America was fairly ambivalent. So to understand America's ambivalence, one has to look at how American publishing industry was responding to the question of copyright. So for a long period of time, American publishing industry impressed upon its policymakers that we need not extend copyright protection to foreign authors because the European literature was freely available to American established publishers, and they didn't have to pay royalties, and therefore they were like holding a de facto monopoly of European literature within America. They could justify to the policymakers by aligning this with the question of making cheaper literature available to American population, therefore greatest good of greatest number of people. But interestingly, these established publishers subsequently, when were facing a challenge from new set of publishers from a different part of America, suddenly realized that it would make sense to impress upon policymakers to extend copyright protection to foreigners also, because they realize that the new challengers do not have deep pockets. So if we have to outdo the competition this way, if we extend the copyright protection to foreigners also, because we have deep pockets, we would be able to strike licensing deals with those foreign authors, whereas the newcomers would not be able to do so, and therefore we would be able to secure our monopoly over the trade. Okay, and therefore suddenly there was a pressure put on the American policymakers to extend copyright protection to foreigners also. Of course, there was ultimately a compromise in the sense that although protection was afforded, but with the condition that publication of the foreign work will happen in America simultaneously as it would happen in Europe, right? So that was just one example of how, in terms of freedom to exploit the possibilities of how you construct your intellectual property regime, private interests also played a major role by sort of aligning themselves with what was perceived by the state as matter of social welfare, public policy, national security, etc., etc. Okay, so so the moot point I was trying to say was, before TRIPS came into existence, there was a space of freedom available to many developing countries in respect to how they would constitute their intellectual property regime. Okay, having said that, it would be wrong to say that the issues of concern or issues of tension vis-a-vis international intellectual property regime arose only after TRIPS came into existence. In fact, for the developing world, countries like India particularly, conflict with international intellectual property regime started prior to TRIPS. Okay, so one such example is the conflict with respect to patenting of traditional knowledge products. Some of you would have heard of neem patent, haldi patent, etc., and the controversies vis-a-vis that. So that happened prior to TRIPS. Okay, particularly the neem patent controversy, whereby an American company patented neem extract, which could be used for its antifungal properties, whereas in India for centuries neem had been used as as a sort of ingredient to keep away insects from the crops. Okay, so that controversy arose prior to TRIPS, and that is where a developing country like India came into conflict with international intellectual property regime in some ways. Okay, so it would not be right to say that TRIPS is to be blamed particularly for this tension between developing countries and international intellectual property regime. Okay, but TRIPS brought its own sort of characteristics to this tension. Okay, and one of the most identifiable characteristics when TRIPS got adopted was that prior to TRIPS, although examples like NEEM were there, as I've just mentioned, prior to TRIPS, if we can use the word piracy just for the sake of it at the moment, piracy was a two-way process. Okay, so if let's say the Western world was pirating our traditional knowledge, like in the case of TRIPS, we were also equally, adept at borrowing their knowledge, be it the films, the books, or the pharmaceutical products. And that's how the generic industry in India or some other parts of the developing world came up, right? So copying, let's use the word copying, that's more neutral. Copying was a two-way process, and there was a symmetry vis-a-vis that. And hence, even if issues like NEEM would crop up, in between, the sense of, gross political injustice in intellectual property regime was possibly absent or not present in a major robust form. That changed after TRIPS because TRIPS made it one-way street. Okay, so TRIPS now required that the intellectual property generated in the corporations mostly located in the developed world would be secured through very well laid down standards, and would also be backed by enforcement mechanisms plus the dispute resolution mechanism of the TRIPS agreement, but left what many in the developing parts of the world believe to be their intellectual wealth, particularly vis-a-vis traditional knowledge, etc., as part of public domain. Okay, so what belonged to me remained part of public domain to be exploited by anybody and everybody, whosoever had the capacity. What belonged to you got secured as your private property, not available to anybody. So this asymmetry, therefore, caused initial set of heartburns vis-a-vis TRIPS agreement. Okay, so, and of course, as I said, TRIPS agreement established minimum standards. Unlike prior to TRIPS, where countries could discriminate between different forms of technology vis-a-vis the strength of the patent, post TRIPS, it was a clear mandate that you shall give patents without any discrimination against any field of technology. Okay, so a major part of your freedom was taken away by prescribing that you have to grant patents to all fields of technology without any discrimination, right? So India could not therefore continue to discriminate against, let's say, pharmaceutical products or chemical products and stuff like that. Okay, so question can arise. Also, the moderators who are there, you can let me know if I am crossing my time whenever. Okay, because I'm not keeping an eye on the time. So when it came to, so the question is then, how do we explain, the sort of acceptance by countries of the developing part of the world, countries of the South or the East? How do we explain their acceptance of TRIPS agreement? Okay, in what circumstances, in what ways did they accept TRIPS agreement as the sort of central location around which all intellectual property related debate has to move, right? So there are different perspectives on how TRIPS and its adoption by developing world gets explained. Some people say that it was purely coercion. So there is a coercion narrative. It is believed, like I said, that it laid down very clearly established standards with the threat of enforcement through WTO dispute resolution mechanism, which was absent prior to TRIPS, when Berne Convention and Paris Convention were the main treaties regulating international intellectual property scenario. And as I said, it took away many of the liberties from the developing countries, liberties which were used by the developed world at different points of time in their history. So it took away their liberties. So logically speaking, a rational mind would not really say, would not really adopt such a set of restriction, right? So for some people, this gets explained only by saying that there was arm twisting, there was coercion, and nothing else explains that. Okay, Professor Jagdish Bhagwati, some of you would be aware of this name, who's otherwise belonging to if we have to divide economics into right wing, left wing, or liberal economics versus Marxist economics, he's somebody who should be seen to be supporting TRIPS agreement because TRIPS agreement is supported by liberal economics. Okay, but he was one of the strongest critics of TRIPS agreement, and he suggested that TRIPS does not involve mutual gain. Rather, it positions WTO primarily as a collector of intellectual property related rents on behalf of multinational corporations. Okay? So there is one theory that TRIPS basically was coercion and people were arm twisted. And there are reasons to sort of support this argument. I'll come to those reasons in a minute. The other theory is that it all happened in ignorance. Developing countries did not realize what they were signing in for, and therefore they did not know the implications of signing such an agreement. Let's say somebody could say today that developing countries did not know that in a situation like this of pandemic, that TRIPS agreement would be an obstruction the capacity of countries like India, Brazil, South Africa to utilize their capacity, industrial capacities to maximum in order to help themselves and also help other sister developing countries. Okay. So ignorance is one such narrative. Although people who oppose such narratives suggest that the manner in which some countries of the developing world were engaging with intellectual property question prior to TRIPS suggests that they were not ignorant with respect to the intellectual property and its importance. Okay, so for example, developing countries had secured, within Berne Convention, had secured in one of its revisions in Stockholm the right to get the literature translated into their languages if the copyright owner is not doing that within a reasonable period of time. Right to also, use compulsory licensing to make written material or literature available for educational purposes, etc., etc. So some people say that it's wrong to say that developing countries were ignorant, but there is a grain of truth in such an assertion because with respect, I'll use this example with respect to, let's say, integration of biotechnology with agriculture and dependence upon biotechnology based agriculture on intellectual property rights. This particular sort of integration was surely not so much in the knowledge of the developing countries as one would expect that the corporations based in developed part of the world would have anticipated this possibility. And the third and the most popular of the explanations is that this was a bargain where developing countries got what they wanted and the developed world also secured what it wanted. So what was demanded by developing countries as part of this theory? They suggest that developing countries were trying, because they were anyhow weak in terms of their intellectual property grounding. It's not that India was a big innovation hub of the world and therefore it was looking for securing its innovation across boundaries. India was more worried about selling its agricultural products, its textile products in Western world, and therefore it wanted easier access to the markets in that part of the world. So India got offered that, and in return India had to agree to higher standards of intellectual property and to surrender some of the liberties it had exercised prior to TRIPS vis-a-vis how to frame its intellectual property laws. Okay, so this is the bargain theory, which suggests that it was a give and take, and there is nothing sort of unjust or unfair in such a situation. Okay, it is also suggested that by signing up for TRIPS, developing countries also secure themselves against potential unilateral, sort of challenges of sanctions or reprimands by the developed world. So America particularly had become infamous by enacting a particular clause in their Trade Act called so there is a section called 301 in their Trade Act of 74, which got amended in order to ensure that as part of the mandate of 301, they would do review of different countries with respect to their intellectual property laws, and countries which are found to be not satisfactorily having intellectual property regime would be then hit back against with respect with the help of sanctions and other kind of coercive mechanisms. Okay, so 301 mechanism or special 301 mechanism emerged as a particularly infamous tool in the hands of the US policymakers to arm twist countries to fall in line with American standards of intellectual property. So it is also suggested that by signing up for TRIPS, the countries were also trying to secure themselves against such unilateral actions. Okay, my own teacher in intellectual property, Professor Vivek, I think he has a lecture with you tomorrow, if I'm not wrong. he presents this particular scenario in an interesting manner. So he says, like, if you were given an option of fighting a heavyweight boxing champion, where would you like to fight? That the battle is totally against you. The equation is against you. You are going to be defeated severely, but you have no way out. So where would you like to fight that battle? Would you like to fight that person in the open streets, or would you like to fight the person in a ring? Right. So the logical answer is we would like to fight the person in the ring, because we know that before we die, or before he sort of bludgeons us with extra set of punches, the referee would blow the whistle and stop the fight. So that's one way of sort of explaining this bargain which happened as part of TRIPS, that America or European countries being that heavyweight boxer, we secured ourselves against those boxers by going into the ring called TRIPS. Okay. But then many people are not satisfied with this explanation. Okay, some scholars believe that even if TRIPS was a bargain, it was a bargain which was failing on what is called as the theory of democratic bargaining. And I'm using this terminology, borrowing this from a paper written by a very famous professor, Professor Peter Drahos. I don't know whether it is his theory or he himself borrowed it from somewhere, but I am surely taking it from his paper. So it's called theory of democratic bargaining, whereby only if three conditions are met, that a negotiation would be said to be ethical and appropriate. Okay. The first condition is condition of representation, that throughout those negotiations, all parties must have representation. The second is condition of full information, that throughout those negotiations, all parties must have full information about what is getting debated, what are the implications of what is getting debated. And the third is condition of non-domination, that is, there should be no coercion in those negotiations. So in Peter Drahos' opinion, on all these three fronts, TRIPS agreement failed. On the question of the first condition, condition of representation, even though countries like India, Brazil, South Africa were playing an active role there, yet their presence was allowed only after certain internal settlements between US and European community particularly, and then in an extended form, Japan, Australia, Canada as Quad, only when some settlements were already done, in this group, right? So a package was already constituted, which was offered, and some possibility of tweaking was just offered to the developing world, right? So, so therefore, it was failing on the question of representation. On the same reason, it was also failing on the question of information, because, as I said, if I'm not part of the negotiations from the very beginning, then information which was sort of thrashed out in the initial set of negotiations, I was never privy to that information. And with respect to non-domination, I've already given you the example of usage of 301 review, special 301 review, which was used by US to sort of particularly poke more adamant countries like India, Brazil, etc., in order to make these countries fall in line. Okay. Also, as a result of such threats, one-to-one deals were signed by US with countries like Saudi Arabia, Colombia, many other countries. Okay. So once you had one-to-one deals being done with some of these countries of the developing world, it was easier for them to now say, okay, we agree to a multilateral treaty like a TRIPS agreement. Right? So even if it's a bargain, it was a bargain which did not, in the opinion of scholars, did not meet the criteria of what could be called as democratic bargain. Right? So so this is how, therefore, developing countries, from our perspective, let's say India, was engaging with international intellectual property regime. Okay. So once TRIPS got signed, we had this paradoxical situation where we entered into a state of anxiety and apprehension vis-a-vis TRIPS and what it can do, to a phase, as I started my presentation by saying that the recent past has been a past of relative calm. So after TRIPS, we had a phase of big anxieties to a phase where there was a relative calm. Okay, why were there anxieties? That is fairly obvious to sort of anticipate. As I said, with respect to the implications of TRIPS agreement, people had not comprehended fully when they were signing it, but soon it started getting understood, particularly when biotechnology was emerging as major area of science, and when integration of agriculture with biotechnology was happening. It was understood by many countries in the developing world that their capacity to freely take decisions vis-a-vis their agriculture was getting hampered by this requirement to be compliant with TRIPS agreement. Okay, so that was one major reason as to why there was major anxiety vis-a-vis TRIPS agreement. Okay, then secondly, in terms of the theoretical justification for a strong, well laid down intellectual property regime, the West had still not sort of offered sufficient explanations. Okay, I'm not saying that the obligation to offer justifications laid only with people in the West. Anybody who's engaging with the question of intellectual property would independently be looking at how do we justify intellectual property. But the fact that the regime as a package was offered by West, it was more obligatory on the scholars in the Western world to offer sort of foolproof explanations as to why such a regime would be beneficial. Okay, and the most prominent of the explanations which are on offer since long vis-a-vis intellectual property is a utilitarian explanation that in the simplest form of it, it is an incentivization based explanation, that we incentivize people to create more, and therefore having intellectual property regime is better than not having intellectual property regime. Okay, but the problem with this explanation was that we had establishment of a regime without empiricism really justifying the claims which were otherwise intuitively made with respect to the correlation between intellectual property and incentivization, right? And a point of particular concern was, which would be appreciated by all, I assume, that even if non-critically one were to agree that that under incentivization can lead to underinvestment in generation of useful arts and sciences, one would also similarly agree that over incentivization can also lead to problem when it comes to optimal utilization of human capacity to churn out creative sort of things, right? So if on one side it is about incentives, on the other side it is also about raw materials which are your thoughts, somebody else's thoughts, which I may rely upon in order to build upon that, right? Who said that? Newton said that famously, that if I could see that far, it is only because I was standing on the shoulders of the giants, right? So in terms of the empirical justification for intellectual property for a regime which had already been imposed upon the world, the literature was still short of creating a foolproof sort of evidence-based justification for it. Okay, different studies are were surely present, but a comprehensive foolproof case for such an arrangement was absent, right? So any mismatch between right amount of incentivization and actual innovation was going to have particularly drastic for the developing countries, because they had less means of negotiating with the consequences of such the consequences of lopsided intellectual property regime. Okay, so basically, ultimately, as a sense of grievance, the developing world believed that the ladder of freedom vis-a-vis intellectual property, which the developed world had used to sort of make technological strides, that ladder had been pushed away when it came to the developing countries intending to use the same ladder. Okay, so this is a story up to a long period of time as to how developing world engaged with the international intellectual property regime. But interestingly, counterintuitively, paradoxically, whichever way you want to put it, in the recent past, as I said, there is a greater sense of comfort with the TRIPS-centric intellectual property regime. That comfort arose from multiple factors. Firstly, the developed world also became disillusioned with TRIPS agreement, and they believed that what all they wanted to secure was not coming their way through this agreement, and therefore they went on a process called establishing a TRIPS plus regime, whereby they started signing free trade agreements, one-to-one agreements with countries requiring protections over and above what TRIPS would mandate. Okay, so in a relative sense, TRIPS suddenly started looking good, right? It's like against black, gray would look white. So TRIPS suddenly started looking good to countries, because the alternative was the regime shift, which was being attempted through FTAs or through attempts like ACTA, etc. And TRIPS was therefore looking good against such a background. Also, slowly countries started realizing that TRIPS actually had a lot of flexibilities inbuilt. this particular factor remained sort of subdued in the initial phase of discussions, where standardization of minimum standards was more focused upon. But as countries started working along with TRIPS agreement, they realized that there was a lot of space available to them in order to sort of make sure that many of their policy-based concerns get taken care of, right? So I'll give you some examples. For example, TRIPS permits compulsory licensing and governmental use of patents. It allows parallel importation. Okay, it does not specify what kind of exhaustion regime a country has to follow. So India can decide to follow an exhaustion regime whereby importation of an IP product from America, Bangladesh, Nepal into India would not be an issue. Okay, so that freedom was given to the countries. Similarly, TRIPS does not require you to provide patents on new use of already known substances. Okay, in many countries in the West, that is the rule. Whereas in India, novelty in that sense is absolute, and it defeats any claim for new use of medicinal use of a patented product. Okay. Similarly, it does not mandate that you have to sort of vis-a-vis pharmaceutical products. It does not require extension of terms in order to compensate for loss of time as a result of meeting the regulatory procedures. Okay. Again, I'm assuming most of you would be aware of the fact that I may secure a patent before I actually have the authorization to sell something in the market, particularly pharmaceutical products. And securing that regulatory approval may take a lot of years. So a lot of my patent life gets eaten up by this regulatory process. Okay, so many countries in the West have a compensatory mechanism for that, but India need not have it because TRIPS does not mandate it. Okay. Similarly, TRIPS does not restrict the capacity of competition law or antitrust law to regulate the market players when it comes to utilizing intellectual property laws, to their advantage, right? So, so these were the reasons as to why TRIPS sort of became a matter of comfort for the developing countries slowly. Okay, what added to this sense of comfort was some achievement which the developing countries could secure for themselves, while trying to influence the norm setting in international intellectual property framework. Okay, and Doha Declaration emerged as one of the biggest examples of that, right? So this particular scenario where we filed for a patent, where we proposed a waiver, okay, is a second episode in that line. The first one was Doha, which was sort of actuated or necessitated by the HIV, pandemic in the world. Okay, it was realized that the compulsory licensing provisions of the TRIPS agreement were not good enough for those countries which were lacking in their manufacturing capacities, because compulsory licensing, conceptually speaking, originally requires you to utilize products made out of compulsory licensing for internal purposes. Okay, for your own within your own territories, not to export it. But this would help only those countries who could manufacture products within their own territories. But majority of the poor world did not have that capacity. So if a country like India could help, compulsory licensing was not allowing India to help, right? So that modification was made possible through para 6 of the Doha Declaration, which was subsequently absorbed as Article 31 bis, okay, which now permitted such an arrangement to take place, okay, where a country lacking in manufacturing capacities could secure pharmaceutical products manufactured under compulsory licensing, offered by an undertaking, situated in a different country. So that was one big sort of boost to the confidence of the developing countries that TRIPS centering intellectual property regime can be affected, manipulated, impacted by the concerns which developing countries have. Okay. In many ways, some scholars have also suggested that this was also a declaration on the part of developing countries that if it is about the national welfare considerations, then we would take measures where TRIPS would not be seen to be a sort of hindrance to our capacity to respond to our needs. Okay, so that particular observation should then be sort of extended to what is being done by countries like India, South Africa through this proposal of waiver, which is put forth before the TRIPS Council. Okay, so irrespective of what is its practical utility, how far would it go in actually ensuring that we have sufficient amount of vaccines being created? Many people, particularly Europe, in responding to this, was saying that there is no direct correlation between intellectual property and capacity to manufacture medicines and various pharmaceutical or medicinal products. It's more about infrastructure and various other issues within the countries. But from a international political angle, this attempt is an attempt to see again how far is international intellectual property regime responsive to the concerns which are emerging from developing countries, and how far can developing countries in a way impact the norm setting in international intellectual property regime when they look at it from their perspective, from their concerns. Okay, so I think I'll stop here. I'm sure I've crossed the allotted time by a fair amount, and I'm sure my moderators would excuse me for that. But if there are any questions which are in the chat box, I would make an attempt to answer those questions.
Thank you for your insight on everything, sir. It was definitely helpful. And yes, it did go longer, but it was because of all that you had to contribute to your topic.
I can't hear you, Shireen. Your screen is stuck. I'll stop my video so that.
Connected with us?
Yeah. Can you speak again?
Yes, sir.
Yes.
So I was saying Pankaj Sahay is asking if there's any other amendments under TRIPS articles for anti-competitive licensing.
Is there any other what?
Are there any amendments under TRIPS articles for anti-competitive licensing?
Okay, I'm not fully getting the question, but let me just try to respond. I mean, so TRIPS Article 40 speaks about the possibility of competition law to regulate the IP-based agreements, and it fairly, generally speaking, it just leaves it to the countries to decide for themselves what kind of licensing agreements they would deem to be problematic from their policy perspective. Okay, so there is a space of freedom which is available under Article 40 of the TRIPS agreement, and countries are free to decide for themselves what kind of competition law they want to have for themselves.
I hope that answers the question. The next question is by Vamshi Krishna, who's asking, what are the hindrances to TRIPS in India, especially with India having such a large unorganized market?
Again, can you ask the person asking the question to specify? I mean, it's very general. I don't really understand the scope of it.
So let me ask something that was running in my mind while you were speaking. You mentioned about Article 301 of the US.
Section 301 of the US trade.
Section 301 in the US. I wanted to check how successful this has been, like right now. So how successful has that been right now? That clause.
Successful for America, or successful in what sense you're saying?
Successful for, like you said, it's going to boost the market. In patenting sense. So how far has that been successful?
No, what did I say? It's going to. It's going to. Can you repeat what you thought I said?
So can you hear me?
I can hear you. Yes, I can hear you. Am I audible?
Yes, sir. Now I can hear you. So
I'm saying, can you repeat what you thought I said?
So Section 301, you said there was an amendment to the clause. So how successful has that been for America?
No, so let me just clarify that again. So I was just saying, I was just highlighting the unilateral mechanisms which were used by some countries like America in order to make it possible for themselves to ensure that what they are proposing as international intellectual property regime gets universalized. Okay, so as part of that attempt, under a particular act in America called US Trade Act of 1974, there is a section 301, under which they would otherwise review different countries vis-a-vis how conducive trade environments are in those countries when it came to American corporations trading in those countries. Okay. Now in 1988, they made a modification in that act, in that particular section, so as to also include within the possibility of of what all will be taken into account to review the possibility of taking intellectual property on board in order to review the countries. Okay, so that's called a special 301 review, under which different countries are categorized on the basis of how robust their intellectual property protection is. Okay, so there are three categories: priority watch list, priority list, and watch list. I hope I'm getting the categories right. So if you're falling in the severest of it, which is priority watch list, then prior to TRIPS, there were unilateral threats of sanctions. Post TRIPS also, that categorization is seen as a reason for America to then take you to dispute resolution body in WTO, and in a way sort of force you to agree to how America is reading a particular provision of the TRIPS agreement, and amend yourself according to that.
Right, I got it now, sir. Thank you so much. So I think we'll take one last question if it's okay with you.
Yes, because I also see, I think Ms. Bindu Sharma is also waiting. I'm eating
Yes,
into her.
next.
Yes.
So I think we'll just take one last question.
Sure.
Kavita is asking, will
Who asked?
MPP work better in the context in the COVID scenario?
Sorry, again.
So she's asking, will MPP work better in the context in the COVID scenario?
Whether MPP.
Yes, sir.
What is MPP? I'm not recollecting that.
Kavita, could you please specify your question better? Medicine patent pool.
Medicine patent pool. So patent pooling. So you see, it depends how patent pool. So WHO also started its own sort of pooling attempt in the name CTAP. Okay, COVID technological. I'm not recollecting the full form of it. CTAP. Okay, but in terms of the response from the private sector, it was not a very robust response, which also resulted in why this waiver proposal was mooted by countries like India and South Africa. So the point is that pooling is surely a solution to resolve many of the market problems. But in a desperate situation like pandemic, would voluntary pooling be good enough? Because ultimately you're relying upon the sort of good sense of the individual market players. Whether that will be good enough or not is difficult to say, and that's why a more secure kind of option in the form of having a waiver is probably what is wanted by countries like India and South Africa.
Perfect. Thank you so much for answering all the questions, sir. I'm sure everyone enjoyed your session.
Thank you. Thank you.